Thank you very much, Professor Jen Taub, for coming on Objections. Very happy that you're with us this week to discuss a couple of topics, but let's start out with the $4.5 billion settlement with the Sackler family that came with a number of conditions. You are the author of a wonderful book that I recommend that our listeners read called Big Dirty Money. And one of the things that you write about is about the wealthy and powerful getting away with things. How does this settlement and in combination with the prior settlements stack up with that trend in justice?
Well, thanks so much, Adam, for having me here. And yes, the Sacklers are kind of poster children, or Purdue Pharma is the exemplar of the very powerful corporations and wealthy getting away with crime, essentially getting away in this case with violating the Food, Drug, and Cosmetics Act. Not just one time, but back in 2007 settling criminal charges. Now, again, settling criminal charges back in 2020 and civil charges with the federal government. And that cost the company $8 billion, right? And now settling up with the states for what, again, $4 billion sounds like a lot of money. But at the end of the day, the family that made billions of dollars from selling a highly addictive drug that the corporation fraudulently peddled as safe and effective, and not as addictive as other opioids, they will still be exceedingly wealthy, and nothing will bring back the lives of the people who lost their lives to prescription opioid addiction, or the suffering of families who aren't as well off as the Sacklers as a result of their behavior. I
Mm.
mean, so to me, it's a financial settlement, just like the criminal settlement and civil settlement with the federal government was. The settlement with the states are civil settlements. Everyone, the company is paying money. Some money is coming out of the Sackler family's own fortunes. But there is this time around no one being no executives being indicted, certainly no members of the Sackler family yet. And let me just add one more thing. In looking closely at this for the book and then for this update I'm doing for the paperback that comes out this fall, the settlement in 2020 with the federal government happened under the Trump administration, before Biden came into office. And what's amazing, what it revealed is that the criminal violations by Purdue Pharma, the company that makes OxyContin, went from 1996 through, um, sorry, the original settlement from 2007 had to do with misbranding this drug from like right from the start, from 1996 to 2001, misbranding it as much safer than it was. And there was a criminal settlement with the corporation. They settled for $600 million. A few executives plead guilty, some misdemeanors, don't spend any time in jail. Okay, so that settlement for that behavior that ran for 5 years, that settlement happened with the federal government in 2007. So this is what's critical. They literally, the guilty plea comes in 2007. With the guilty plea is that settlement I told you about. But what's amazing to me is that was May of 2007, literally, like when they walked out of court from May 2007 till at least March of 2017, they went back to their illegal drug dealing scheme. So the recent settlement, the criminal settlement, the one that was $8 billion for criminal and civil charges from the federal government, including misbranding and more, that went on right from the moment that they settled the other case.
Mm.
So to me, what this is an example of is, a slap on the wrist. You pay a fine, you continue forward. These criminal settlement from 2007 was just the cost of doing business. The criminal settlement in 2020, and civil settlement, and now this one in 2021 with the states, yet another slap on the wrist. Like you said, the difference here is they can't be involved. Well, one of the biggest differences here is they're not going to be able to be personally involved in the sale of opioids, the Sackler family. And another penalty is they can't lend their name, at least for a time, to certain charitable organizations, like the Sackler family's name being at the Met and other art museums. But the reality is, their names won't be taken down from the places that haven't taken them down or covered them, and that's hardly the same thing as a true criminal sanction for someone for an entity that was involved in illegal drug dealing and led to hundreds of thousands of deaths.
Mm.
This kind of sale of prescription opioids.
And one of the things that the Sackler family was very quick to point out in the wake of the settlement is that it did not force an admission of wrongdoing or liability. And so, if you could talk about that practice, that's a very old practice where prosecutors have tried to reach the deals that they could with these clauses that could be read as allowing defendants to save face. What do you think about that practice, and can you expand on the history a bit?
Yeah, so just to be clear, the corporation Purdue Pharma actually did plead guilty 2 times. So that's
Right.
stronger than what usually happens. What usually happens with a large corporation when there is evidence of criminal wrongdoing that the prosecutor, could bring a case. Usually what happens these days with the big ones is they enter into what's known as a deferred prosecution agreement or a non-prosecution agreement. So this is, and then the charges never actually are brought if they kind of comply and behave themselves for a period of time. That is the norm. So this is stronger than the norm. But you mentioned another common theme that we see, which is a corporation can enter a guilty plea, but you're saying the individuals never admit to any wrongdoing. The Sackler family members did enter into a civil settlement, but the tradition of having either an enterprise or individual settle a civil case and not admit to any wrongdoing is designed to preserve or to protect them from lawsuits by individuals. Because if you had a final judgment on the merits that involved an admission of certain facts, then that would open them up to additional liability. Although they've already, I think, been sued. I think there are numerous class action suits also going on that are settling.
Right. Absolutely. And in terms of the press conference announcing it, you have these very tough prosecutors announcing what, as you said, 4.5 billion sounds like a big number. There's this lifetime ban, and at the end of the day, they're a little apologetic. It sounded from the sound of the conference. Letitia James said this wasn't a perfect deal, in her words, because there is this perception that they're getting away with things. She mentioned one more thing in the press conference, that this doesn't mean the end of any potential criminal liability from the states, that the deal was silent on that. What do you think the odds are of that potentially boiling up?
I mean, I would think that traditionally speaking, criminal cases go before civil cases. You would think that they would have already brought those cases at this time. And I think at least at the federal level, the sort of the I wouldn't say understanding, but the suspicion at the federal level, the November 2020 settlement was the end of the matter. That the Sacklers gave up, so much money, the $8 billion from Purdue, and then hundreds of millions of dollars. I don't remember the exact number from themselves for themselves. That was a way to kind of insulate themselves from individual criminal liability. So it's it's kind of astonishing. Yeah. So the Sacklers back in 2020, the federal case, they settled for 225 million out of their own fortune, and it was only their business that did the 8 billion that included the civil and criminal. But I just cannot imagine. Look, it's really up to Merrick Garland, and I don't see that he's made white collar crime or criminal enforcement a priority. And if there was an unspoken deal with Bill Barr's Justice Department, and the norm is to allow those unspoken deals, I don't know. I'm just speculating to move forward. It doesn't seem to me that Merrick Garland would bring this case. against them. And I don't know, honestly, whether there's evidence that any family members had the requisite, level of knowledge to bring the criminal charges, right? Because even though they settled for violating the False Claims Act. The False Claims Act, this federal statute that's been around since Lincoln, is about allows for criminal and civil charges, right? So I just don't know what evidence there is. But assuming for a second that there's sufficient evidence to bring criminal charges against the individual family members, I wouldn't doubt for a minute that the number was so big on the Purdue side and not the individual side, that it was a tacit understanding that they wouldn't be charged. I think that's how stuff goes down, and it's ugly, but there we are.
And what we're talking about broadly is white collar crime. There's this passage of your book that just really sets it out in a very magisterial, sweeping historical scope. Can you give listeners what you discovered to be the provenance of white collar crime? Where does that come from? Where do we get that understanding?
It's such a great question because everyone thinks they know what white collar crime is, kind of like we think we know what people mean when they say family values or, healthy food. But as it turns out, white collar crime is not a generic term. It actually meant something originally. It's now become a little bit of a Rorschach test. So the origin of the phrase white collar crime, it dates back to 1939. It was coined by a sociologist by the name of Edwin Sutherland, and he introduced it at this, on a cold December night in Philadelphia, in front of a group of scholars. It was meant, it was probably, it was probably not. He probably didn't expect it to have be such a hit and be so long lasting, because this was a scholarly talk. It was for the American Sociological Association. So he gives this talk called The White Collar Criminal. A decade later, he writes a book called White Collar Crime. And what he meant by this concept was that a white collar criminal was a person of high social status and respectability. So you lead with kind of a status, high status person, respected in his community, who commits crime in the course of his occupation. So the first half is about status, social standing, and the second half is restricting the type of crime a high status person would commit to something done in business in the course of their occupation, as opposed to, you would think, a kind of vice crime or a crime of passion. This wouldn't be, murdering your wife because you find out that she's having an affair, or it wouldn't be, whatever kind of drug they would have been doing at the time. This wouldn't be like selling opium or whatever was going on at the time. This wouldn't be, you know, uh, the kind of racketeering or organized crime activity. It was meant to be, he was specifically looking at the wealthy and well off, the upper classes, committing crimes inside of business. And so that was his definition. It was when he wrote the book that came out 10 years later. He died less than a year after the book. It was so sad walking back to campus. And he never saw the legacy. His book, White Collar Crime, was mostly about corporate crime. And if you think about the time period, I know all of us are too young to remember Teddy Roosevelt and trust busting, but a lot of the work what he was writing about was looking back to the early 20th century, looking back to antitrust crime, industrial accidents, intellectual property enforcement. And so he really was focused on corporate wrongdoing, and to some degree things like embezzlement, bribery of public officials, and things like that. So that's the origin of the word. Now people use white collar crime. Lawyers like myself are mostly to blame. We kind of ignore status and focus just on conduct. So we think of it white collar crime, not the white collar criminal, if that makes sense.
Yeah.
So ordinary people think of white collar crime as wealthy people getting away with economic crime, but lawyers try to look at a series of federal or state statutes and say that's a white collar crime or that's a white collar crime. And very often, ordinary people, poor people in blue collar workers get charged with so-called white-collar crime, and that's not what Sutherland was trying to do. And let me just say one last thing: is what was so controversial about what he was doing, which may be considered controversial today, ironically, was to say that it wasn't poverty that led to crime, and said that our notion of what crime is, robbery, burglary, things that happen sort of face to face on the streets, was incomplete and inaccurate. And that if we only looked at the police records and police reports, we would have a sense that poor people, disadvantaged people were committing all the crime. But if you actually defined crime more broadly and looked at the crimes that never got charged, often, or the kinds of things that people got away with because they were too powerful to be charged, or they changed the law to avoid, so that what they were doing wouldn't be unlawful. That was a bigger net, and you would actually see that. An example he gives in his speeches, you would actually see that a manager of a major grocery store costs more to the business than a shoplifter or something like that. But we wouldn't
Mm,
actually measure that, might not actually get reported, and so we might not see it.
mm. So, speaking about alleged crimes by people of status, let's turn to the Alan Weisselberg state case. Prosecutor Vance, the DA, has just charged Alan Weisselberg with what he alleges to be a 15-year conspiracy.
Mhm.
And what's your immediate reactions to that case? There's been anticipation for 2 years. This has gone to the Supreme Court twice. Was it was it what you expected from that buildup?
Well, I love, because it gives me an opportunity to give a mini lecture. I love how you called it the Weisselberg indictment. By love, I mean hate. Because actually, the case was brought against two Trump corporations, and Weisselberg is the third defendant named
True,
in
he's
the
a
indictment.
co-defendant.
And so the genius spin that was able to happen before the indictment came out was to talk about it as a case against Weisselberg, which in some ways the emphasis is on Alan Weisselberg, because we believe strategically the case was brought to try to encourage him to flip on
Mm,
hires up, including perhaps the former president himself. So just to be clear, two businesses which were considered, which use the name, the Trump Organization, which actually isn't an entity; it's more of a description. Um, we have um, we have both of them, the Trump Corporation, and also I think it's the Trump Payroll Corporation, who were charged. These are New York
that's correct.
entities, and they're charged with all the same things Weisselberg is except one. So, am I? Is it what I was expecting? I wasn't expecting much at all. So I'm
Mhm.
actually glad that, since there seems to be evidence of, as you said, a 15-year tax fraud scheme involving Trump's business organization, and his chief financial officer and some unindicted co-conspirators and other executives. I'm glad that Cy Vance had the courage to bring this to the grand jury, and that they indicted. And I think there will be a superseding indictment. And although this may seem small to some people, I think this is tremendously significant. Given that, I focus on my book on tax evasion, and this is one of the ways tax evasion and tax fraud are the way that the wealthy get wealthier and more powerful, and everybody else, who has to pay their fair share. And if they try to cheat, often there's more dollars spent going after, very poor people who didn't pay tax than is going after the super wealthy. This is data from the IRS that I mentioned in the book that comes from ProPublica.
Mm,
I'm sure you saw the head of the IRS currently said we have about $1 trillion tax gap, which is
mm,
the calculating what the IRS is owed versus what they collect. And the head of the IRS, someone who was appointed by Trump, saying that this is largely due to tax cheats, right? So we have an example here of Weisselberg that calculate the number. There's various ways in which he cheated on his taxes, And altogether, if you add it up, it's over $1 million that he owes to either New York City, New York State, or the federal government. And I know, to me, $1 million is a lot of money. And $1 million here, $1 million there is why we have a $1 trillion tax gap. So I'm always happy to see this when someone who's been engaged in a multi a decade and a half tax fraud is called to answer for that. I think that's great. So it's too bad that that's only happening at the New York County level, and obviously with the New York Attorney General as well talking about bringing things. I'm just shocked that the IRS and the Department of Justice has been silent on this so far.
As a matter of fact, the indictment specifically alleges that there were federal taxes that were not paid. And there has been that allegation went out, I think now weeks ago,
Mm.
and without a peep from the federal government that I've heard. In terms of what you just said about the corporations being overshadowed by that, do you think part of the reason for that is that corporate persons don't have flashy perp walks with with handcuffs? What would increase public knowledge that his organization got indicted too, and that these are two entities, and that itself is a very big deal?
I tried to do that in some of my writing. I did a piece for the Washington Monthly where I tried to highlight that because what folks may remember is before Tish James was the Attorney General of New York, there was an interim Attorney General that started I think it was Barbara Underwood was her name, and while she was in that role, she went to court to get Trump's charitable foundation dissolved. Right? That should have seemed
Right.
like a big deal. The sitting president had his charitable foundation dissolved and had to pay out millions of dollars personally to 8 charities. And I think he and his kids were banned from, I don't know, for life or for a long period of time from ever operating a charity. So what I try to highlight is, the same laws would permit the current attorney general Letitia James to go into court and get Trump's corporations that are organized under New York law dissolved. At this point, because there's a criminal case, this step would be to wait till the criminal case is resolved. But if either Trump's corporations plead guilty, or if a jury finds either of them guilty, like the Trump corporation um, or the Trump payroll corporation, I believe is the name, the one they were also using. If either of them are found guilty, I think that would be good reason for Tish James to go into court and ask for the dissolution. For whatever reason, I think a lot of it has to do with maybe the press not wanting to get ahead of itself, but there tends to be sometimes a big focus on individuals. Um, Sometimes when it's a guy like Weisselberg, right, and no focus on individual accountability when it comes to people like behind the scenes like the Sacklers. It's an interesting thing. They're
Mm.
gonna say, "Oh, you paid attention to the big settlement with the Purdue Pharma, right? And the big settlement with Purdue Pharma previously. These are they make the news, but for whatever reason, folks are kind of ignoring the fact that the two of Trump's businesses were indicted. I think maybe the fact is everybody, it seems like everyone doesn't think it counts unless Donald Trump himself is indicted. Sort of the same thing we're talking about personal accountability with, if the Sacklers knew. Why did they just settle civilly? Those kinds of things. People want a sort of individual accountability, and so I think that's the same kind of sense of frustration. But if you're, I think, the death penalty for a business organization is a big deal. And even an indictment of a business organization um, for it being, a tax fraud conspiracy and falsification of records and some of the other allegations is huge.
Mm. And in terms of how the case is perceived, obviously the investigation is ongoing, and depending on one's perspective, two sayings that constantly come up is either no individual is above the law or the president is different, depending on what your persuasion is. What would the nature of this allegation, the allegations contained in this indictment, be enough to bring charges against a former president like President Trump if he were found to be complicit in this?
Well, I mean, the facts alleged here don't seem quite well. If there was enough to where to indict the president, I think he would have been indicted by now, right?
Right.
But I do think there's some hints if you look closely. If you look closely at the indictment, there's one part of it which is very clever. It describes the conspiracy between Weisselberg and these Trump businesses and some third person who is not Trump, and engaging in this basically off the books or under the table payment scheme where Weisselberg and other executives were able to get more value out of working without paying taxes, like getting a free apartment and free cars and free tuition, and hiding it as if it was a business expense of the organization. And what's interesting, what's interesting here is that if you look at the way the conspiracy is charged, folks should know that a conspiracy usually requires two or more people entering into an agreement to commit some kind of underlying crime. So it could be a business counts as an organization. It could be Weisselberg entering into an agreement with Trump Corporation and the Trump Payroll Corporation, and it could be Weisselberg entering into agreement with another unnamed executive, et cetera, to engage in this tax fraud. And the underlying crime would be these state crimes, or it could be depriving the federal government of money. It can be, whatever the underlying crime is. The idea is that you've agreed to this, and in order to cement a conspiracy under state law, because by the way, even if you don't actually do the crimes, if you conspire, it's its own charge, right? But in order to actually cement it as a conspiracy, you have to take some step more than just talking, because anyone could sit around and talk about stuff. But if you take any kind of step in furtherance of that criminal objective, then the conspiracy is cemented, and any of the conspirators can do it. Now, keep in mind that step could be anything. So if you were going to just by an analogy, if you and I sat here on this phone call and said, let's go rob a bank, like I would never want to do that. And I said, well, I can't help you because I don't have any gas in my car. But then I go out and fill up my car with gas. That step, normally filling up a
It's
car
an
with
overt
gas.
act.
Overt act, you got it. So here, what's interesting to me is there's a list of overt acts did you see this in the indictment? It's
Yes.
fabulous. The very first overt act involves Donald Trump himself. But they were clear. They don't say Donald Trump. They say Donald Trump acting on behalf of the Trump Corporation. So what this act was, let's be clear, one of the key things that Weisselberg is accused of doing in this indictment is getting a free apartment for 15 years as part of his compensation. The book said it was his compensation. That was like 2 sets of books, but never declared it as income to any taxing authorities in New York City. It was in New York City, this apartment, never declares it as income. Very fancy apartment in one of Trump's buildings. So the argument is that the Trump Corporation and Weisselberg conspired to allow this tax fraud to happen. But what was, they're arguing that there was an agreement with the Trump Corporation and Weisselberg, right? And what is the overt act? The overt act was Donald Trump himself, because he owned the building, entering leasing, but he doesn't, even though he owns the building, it's Donald Trump himself as president of the Trump organization, entering into a lease saying that the only person who can stay in the apartment, so the Trump organization is going to lease this apartment from some Trump real estate organization. Trump organization is leasing the apartment, and the only tenants allowed to be there are Weisselberg and his wife, and he must use it as primary residence. So what does that tell you? It tells you Trump knew that Weisselberg was staying there as his primary residence, that it was for him only, and he knew that the business was leasing it. So it shows knowledge, right? But
Right.
obviously missing what we don't know is evidence that Trump agreed to this entire off the books conspiracy. It seems highly unlikely that he didn't. If the reality is, and let me just, he knew about it. We know he knew about it. But if he didn't agree to it, wouldn't he be angry? Doesn't Trump
Mhm.
get angry at people who cheat him?
Mm.
I don't know. What do you think, Adam? What do you think I mean, what do you think the
Let's put it
likelihood?
let's put it a little differently though. Setting aside the alleged fact pattern, what he
Yes.
knew and his actions, putting that aside, are the allegations, obviously the allegations against Weisselberg and the organization are serious. Are they serious enough to bring against a former president?
It's not whether they're serious enough.
Mm.
It's what you're saying is even if we have evidence of his agreement and the level of knowledge necessary to show that he knew it was a violation of law, you're saying even if all that evidence were there, you are you suggesting this is like small potatoes?
Mm.
Is that what you mean?
Not my suggestion. In the sense of, let's put it this way: the Trump has gone to attack the prosecutor's office as political. He has as he has responded to every investigation into his conduct. Do you think that prosecutors might be looking into something that they could present to the public that would shock the conscience enough uh, for
Oh,
whatever public relations fallout might be in charging a former president?
I see what you're saying. I'm so laser focused on this particular indictment. There are other things that are being investigated, as you know, and so you're saying, are there any of those other things would they shock the conscience? So some of the other things that are being investigated is his habit, which his former lawyer Michael Cohen talked about it under sworn testimony before Congress, of making on paper the value of the properties he had look higher when he wanted to get a bank loan, making them
Mhm,
look higher when he wanted to say, look, for insurance purposes, I have this collateral, but making them look lower when he was paying his taxes, higher when he was trying to get an easement so he could get a tax deduction. There's all kinds of games he would play about valuation. But here's the thing, we already knew he was a tax cheat. I mean, we saw the
mhm,
allegations and Suzanne Craig and that whole group's piece about the $400 million allegedly he and his family benefited from his father's estate without paying taxes. So look, I don't think anyone's going to be shocked about anything they find out
mhm.
about him. And in fact, we have the Mueller report, which makes pretty clear evidence of numerous counts of obstruction of justice. Right.
Right.
So we have him, riling up a crowd to get them to commit, insurrection and physically attack um, the Capitol and Capitol Police and seek out to murder Mike Pence and Pelosi. So what could possibly shock us, I guess,
Mhm,
is so the shock standard really to me isn't the legal standard. If you're talking about um backlash, I think it's a job of a prosecutor not to be concerned with political backlash, but to follow the law and especially to set a standard. Like you said, is it that nobody's above the law? No one believes that anymore.
mhm,
No one believes that, especially after the Trump era. And the number one job, I believe, for law enforcement is to see how far we've slid. Trump made it worse, and to make clear that there's no longer a free pass for people who are either really wealthy and well connected or can whine really loud like
mhm,
Trump does. Because if that's the way it works, you just whine and threaten and complain and hire lawyers, which I guess people do, then we have, two systems of justice, and that's wrong.
mhm.
So I think they should bring the cases they can bring, regardless of what any kind of political fallout there would be.
I think on that note, that's a wonderful note to end on. And thank you again, Professor Taub, for coming on. And listeners, again, read her latest book, Big Dirty Money. Thank you again.
Thank you, Adam.